For Camellia Grill, it's Mr. McDavid first. I guess, and Mr. McDavid with the rebuttal too. Yeah. And please.
May it please the court. I'm Steve McDavid, and I represent Mr. Schwartz and his parties in this case. And I'm going to...
You're going to have to talk up a little.
Yes, sir.
Okay.
Sorry.
That's all right.
I'm Steve McDavid, and
Yes.
I represent Mr. Schwartz and his parties in this case. And this is a case where he no longer has the constitutional right to enforce his state court judgments. Those state court judgments have been completely gutted from him by the federal district court's actions for the last 9 years.
Now, in your brief, you said it was a prejudicial district court. In the relief you're requesting, and also in the brief, you say incredible overreach by our court twice before. So you want all federal court rulings to be vacated back to 2013?
Yes, sir. We'd like the case to be dismissed with prejudice on the Rooker-Feldman rulings.
But all court rulings,
All court
our
rulings.
court twice or maybe even 3 times before.
Yes, sir. Yes, sir. All court rulings. And I'll outline exactly where I think we should address some issues here, in particular whether this was a state court loser, and then secondly, whether Mr. Coder was asserting an injury under the state court judgments. Okay? So that's my 2 main points here. But if I could, let me hit a few key points along the way, some of which are included with a chart that I passed out, I believe, to the judges.
I'm not sure we have that.
I apologize.
Did you give that to opposing counsel?
I'm sorry.
I think at this point, before we decide to accept it, if opposing counsel hasn't seen it, we haven't seen it, why don't you just continue with the arguments?
Yes, sir, Your Honor. Be glad to. Well, Your Honor, I think we first need to focus on the fact that Mr. Coder began this entire litigation 14 years ago when he filed a state court action. And in the state court action, he was attempting to avoid an audit at the Uptown.
We know the history, the audit issue first, then the termination of the license. Those are the 2 state court judgments that you say were nullified.
Yes,
Let me jump with a quick question. Do either of those state court judgments include any reference to the bill of sale?
They do not, Your Honor, and that's because Mr. Coder didn't assert the bill of sale as an issue in the state court.
Right, but you lost that laches argument already once in our court.
Your Honor, he affirmed in the state court in his pleading that Mr. Schwartz owned the IP and that the purpose of the license agreement was to provide the IT to the Carrollton location. This was in the audit of Uptown's books and records in the state court.
I guess what I'm really just driving is I see Rooker-Feldman as quite narrow. You're saying that our court's judgments nullified the state court judgments, the 2 being that he has auditing rights and that the license is terminated. But Judge Jones wrote in the first of the 2 Fifth Circuit decisions, especially in footnote 2, that the license was irrelevant to her analysis of the bill of sale. How could that not then be an independent issue rather than a direct attack on state court judgments that never mention the document that her panel looked at?
Well, by not mentioning it does not mean that it does not directly create a null state court judgment. Both state court judgments cannot be enforced now at all. And that's because the bill of sale...
But you got the audit.
I'm sorry,
you got the audit.
We got the audit, yes.
So it's really the second state court judgment.
Second state court judgment terminating the use of it all over the world and returning the IP to Mr. Schwartz was stated in the findings of fact of the state court.
And yet I thought even in your brief you are acknowledging that really where you think the federal courts went wrong was because they didn't understand that the trademark language in the bill of sale had slipped in as a drafting error. It was meant to be a placeholder. Randy Opatowski was involved. I thought that's what you were arguing to us.
Well, I think that is true.
But that doesn't sound like they're trying to nullify state court judgments. It sounds like, goodness, once focus is turned to the bill of sale, you're acknowledging there was a, quote, drafting error. And yet that led our court twice to say, no, we're not going to accept parole evidence. We're not going to allow you to talk about the licensing agreement because we're interpreting that contract its plain language.
But, Your Honor, what the federal court did was it took the real estate transaction, went outside the 4 corners of the bill of sale and said, oh, this was a going concern. So we're going to throw in the word trade dress into the bill of sale. We're going to throw in goodwill, and he's now bought it all. So they used extrinsic evidence when they chose to through the real estate sale, but they ignored the extrinsic evidence of a license agreement which had been reviewed before the bill of sale, 8 days beforehand, everybody reviewed it, and signed 10 days afterwards. And in it specifically under Section 17 says, this is a complete agreement, it's the final word, and any prior agreements are no longer applicable. The license agreement controls. Mr. Coder admitted that in state court. In all of his state court pleadings, he admitted it. In his first federal lawsuit to prevent the historic designation applying for the historic preservation, he said the license agreement controls Carrollton. So only when he found the bill of sale and decided to change his mind did the bill of sale and the word trademark become an issue. He affirmatively agreed that we owned it for 7 years before the federal court started. So the federal court uses extrinsic evidence when it chooses to, but now we go to the license agreement, which has been held by the state.
That could be error, which you did or didn't, apparently didn't prevail on up to us. But I don't see how that's Rooker-Feldman.
Rooker-Feldman can be brought up at any time to see if the federal court's rulings have essentially gutted the state court judgment, and that's what happened.
But you acknowledge that Judge Jones and then Judge Clement both said they delineated, they explicitly said they were not.
Well, what's left to enforce, Your Honor? I can't go to Carrollton and enforce the license agreement. Doesn't exist.
Well, you've got the injunction, the second issue.
And I can't go anywhere else because nobody can use the intellectual property anywhere in the world except the 2,500 square foot plot in Carrollton. It's the most absurd ruling after selling a building, selling your bar stools, and licensing your intellectual property to then have the other side own 100% of the intellectual property, but they can only use it at one store.
Well, I guess the answer could well be that it's absurd because these documents were poorly drafted.
If they were poorly drafted, they were drafted by Mr. Coder's attorney, Mr. Optowski, who his attorney, Mr. Bernstein, also reviewed and said, yes, let's put this placeholder in there until we sign the license agreement in 2 weeks. That's what the testimony said, and the courts have totally ignored that to say, oh, he bought the building and the trade dress and the goodwill all through this one page, one word.
It's a long, protracted history. You know it a lot better than I do, but I did notice in 2013, in opposition to his petition for a declaratory statement, you opposed federal court jurisdiction on Colorado River abstention doctrine. Do you remember that?
Yes, sir. I believe it was attorney before.
Yes, it was. I guess my immediate thought was that might apply much more appropriately than Rooker-Feldman, because I don't see this as a direct attack on auditing rights or termination of the license. I tend to think the law of the case here is that our court very carefully avoided that. On the other hand, Colorado River abstention could have been appropriate. Whatever happened to that argument?
It's my understanding that the district court said there was no abstention.
And you didn't pursue that on appeal?
We did not. We've not.
And what are your thoughts today? Because that doesn't require the same level of identicality.
Well, I do believe it would be a good issue on appeal. I do. But not here today.
Not here today, okay.
Yes, sir. I think the point is, as much as the federal court tried to not address the prior state court judgments, the practicality is it did. It gutted the entire state court judgment, which said, with Mr. Coder's affirmative assertion, that he owns the IP everywhere in the world, and the purpose of the license agreement was simply to allow Carrollton and other units to use it. That's what the state court held, and that is not what the federal court held. The federal court has held the exact opposite. Mr. Coder owns it, and he can't use it anywhere, and Mr. Schwartz owns nothing. Direct opposite to what the state court said. So I don't understand how Rooker-Feldman couldn't apply in this type of situation. As much as the court has tried to craft around that state court, it has directly attacked it at every stage of the way. There is no provision in the license agreement that can be enforced against Mr. Coder at Uptown. Although he said multiple times, it is what controls and provides me the rights to intellectual property.
What's your best Rooker-Feldman case where the federal court rulings repeatedly, explicitly say they are not implicating state court judgments, and yet the language ends up being written that, well, all 6 of you got it wrong because, in fact, practically, you defeated it?
don't know that I have a
Right.
case that's quite on this point where the federal court intentionally was trying to weave around it. But that's the result, is we have nothing left in the license agreement. We have no intellectual property we own, although it's clear from the intent that you're all aware of.
If you have nothing left, why are you pressing so hard on the injunction?
The injunctions is the alternative. If you will grant Rooker-Feldman, we don't need the injunction.
Are you arguing, or is co-counsel, you're arguing the injunction?
Yes, yes. Sir.
Okay. Do you want to move to that, or do you want to spend a little more time on Rooker?
Be glad to address the injunction issue.
And I guess my first question is, the 8 elements were the ones that, again, our court previously told the district court. What latitude would the district court or would we have to add an element that our court previously hadn't stated?
Well, Your Honor, in the same way that in the state court, the court seems to not want to address the findings of facts, those 8 elements in that particular Fifth Court opinion were not necessary for the ruling. It was not part of the ruling. It was just 8 facts that were recited in the facts of the case. And in that 8 facts, they left off the waitstaff attire, which was in our second amended pleading as well as in discovery.
Remand. You could have moved to amend or correct, right? Because that led to the remand that led to the injunction, right?
Yes, and in the injunction hearing, we argued for the contract termination provision to be applied, which would say that Mr. Coder has to take a step back and can't do anything at all which might imply to the public that there's an association. But instead, the district court used the Lanham Act trademark infringement analysis to determine the elements of the trade dress that he cannot have most, if not all, I think is the way she put it. If he has most, if not all, he's enjoined. But otherwise, if he uses some, but not many, it's very confusing. The law is pretty clear that when there is a license agreement between the parties, the contract should control the termination provisions. And this termination provision asks that Mr. Coder be prohibited from any way implying that he is in any way related to the original thing. Not simply most, if not all, of these particular 8.
So what's the language you want? Any way implying, or just the word any instead of most but not all?
Now, what we would like is that the way the contract reads, the license agreement that we'd like to be enforced, that any action or the continuation of any condition which might suggest to the public that Mr. Coder has any right to the Camellia Grill intellectual property, or that Coder continues to be associated with the Camellia Grill holdings. That's the contract language, which should be the injunction language. Remember that when you breach the contract, you should be punished. And the punishment in the injunction is that it is overly strong, more so than if it was simply innocent infringement. And so case after case we cite shows that he needs to be pushed far back away from the line, but the line is many, if not all, of the components is what he has to stop doing. And so we're requesting that the injunction be as broad, as clear as the language in the agreement. So,
You want to speak to the sanctions issue?
sir,
The sanctions?
I was going to reserve
You were going to reserve that?
Yes,
Okay,
sir.
perfect.
Again, I'll go back to the state court, loser question. It may be that that's not an issue that you all think is important, but the Lance case provides an exception to the rule that you have to be a party to be a state court loser. And one of those exceptions is that they were, excuse me, that there was really 3 exceptions in Lance. One was to be a successor in interest. 2 was that you had been treated as a party to the suit and judgment. And the third, they implied that something more than simple privity might be. And I would say that we are both a situation where Mr. Coder and Uptown was treated as a party to the suit. It was Uptown that was audited. It was Uptown that committed the transactions that were the basis of termination. Okay. It was also, remember, Mr. Coder who had Uptown sign a sub-license agreement with Grill Holding and became subject to the license agreement.
2 questions. One I always ask, what's your best authority that a de facto party can qualify as a state court loser? So best legal authority. Second question is, don't we have a law of the case problem here too, because Judge Jones's opinion explicitly said Uptown Grill is not a party?
Well, the Fifth Circuit also ruled in 2016, while Uptown Grill was never formally involved in the state court dispute, it is an affiliate of Grill Holdings pursuant to Section 4 of the license agreement, and under that provision is included in the term licensee. The licensee under the agreement is required to cause any licensee to abide by the agreement's provisions, Section 6.4, and the licensee agrees in Section 5 that all of the licensor's right, title, and interest to the mark shall remain with the licensor. That's the Fifth Circuit ruling in 2016.
I know your red light's on. You save time and rebuttal, but my other question was your best Rooker-Feldman case for a de facto party qualifying as a state court loser.
Sorry, but I don't have one right now.
Yeah. Opposing counsel. Is it pronounced Hengens?
Hens.
Henskins. Okay, thank you.
May it please the court, Scott Henskins for Uptown Grill and the underlying 136560 case, and for the rest of the Coder defendants in the underlying 14810 and 837 cases. I have with me Ms. Danny Burrell. She'll be handling the Rule 11 sanction issue. We also have Mr. Patrick Betts, who is one of our law clerks. So this is his first trip ever to the Fifth Circuit, so I really hope this goes well. But it's not my first time here. Matter of fact, it's not even my first time in this case involving these parties. It's my fourth. We've done this a lot, and frankly, if I'm being perfectly honest with the court, what he just did is exactly what I expected. They are challenging the underlying rulings of this case constantly. They lose and they complain about it. They lose some more and they complain about it. And he went all the way back to the beginning of time, to 2006, the negotiation of the contracts, 2008 and 9, signing of the contracts, the 9 and 12 rulings. It starts over every time we are here. Every time we are here. One of the reasons why this is so frustrating is because there should be something about the sanctity of a final judgment. There is none in this case when it comes to that side of the room. It's always starting from the beginning, which is why, in my opinion, this is not a Rooker-Feldman case. This case has nothing to do with Rooker-Feldman.
Is it a Colorado River abstention case?
I don't believe it is. I think it's a Rule 60 case. There is a problem here. They are now objecting to the subject matter jurisdiction of the court. There's only two possible ways they can get there. They can go the Rule 12 route, which they tried to do, Rule 12b1 and Rule 12h3, or they have to go through Rule 60. That determination is whether this is a final judgment or not. Rule 60 is relief from judgments, final judgments, orders, and proceedings. Rule 12 is the only chance they got here because it allows you to do it up until the end of the case, right? Even the Supreme Court, on its own motion, can make a rule subject matter jurisdiction argument and kick the case at that stage. But after all appeals are exhausted, now you move into Rule 60. And then the question becomes, is the case final? In this case, it absolutely is. What we asked for in December of 2013 was very distinct. All we asked for was to be declared the owner of the trademarks that are located with or upon the property at issue, the Carrollton location. What did the Fifth Circuit hold? The bill of sale thus clearly and unambiguously transfers to Uptown Grill the trademarks within or upon the Carrollton Avenue location. That's the first March 2016 ruling from this
The
court.
2016 and 2019 both did, of course, remand as to other issues. So
They
what's
did.
your best Rule 60 case that we would give finality as to partial ruling?
Hall versus Hall. It's the Supreme Court case. What's different about this case is that these are consolidated matters. The underlying case, 136560, is the deck action that we filed on the ownership issue. That issue was the first one decided by the court in July of 2015, the district court. That's the first appeal, the March 2016 judgment. What the court did at that point in the underlying summary judgment is she gave us what we wanted, what we asked for, and a little more. We came up here and the little more got sent back down, but everything we asked for stuck. It was not appealed to the Supreme Court ever. What Hall v. Hall says is that when you're dealing with consolidated matters, that there is no merger of those cases that moves the distinction and deprives the parties of the substantive rights they have as if the case stood alone. So if they had never filed their lawsuit suing us, and all we asked for was the 6560 relief, ownership of the trademarks as to Carrollton, that was over. And if Hall v. Hall, the Supreme Court case, stands for anything, it's that you still have your substantive rights in the finality of that judgment, even though the cases are consolidated and even though there's something else still going on in the court. That's where their case falls apart. They cannot get past
I
that.
think I understand that, but you have a lot to cover, so let's just assume we're in the world of Rule 12. Do you still prevail if we have to address Rooker-Feldman?
Still prevail because that's Rooker-Feldman, right? That's the only way they get to the gold, and that's Rooker-Feldman. Rule number 1 in Rooker-Feldman. You got to have a state court loser. Where are we a state court loser? Uptown Grill is the plaintiff in 6560. It is the party that was the signatory to the bill of sale. It is the party that got the judgment in its favor, and it is the party prevailed in March of 16 in this court. Uptown Grill's name is never mentioned in any of the judgments, reasons for rulings, writs, or appeals in the underlying 2009 and 12 matters. Not one time. The bill of sale, not mentioned one time in any of those.
And yet the record does seem to imply it was just an accounting vehicle for the larger constellation of...
And now we get into parole evidence, which this court and the district court said we cannot get into. What we have here is a bill of sale that is clear and unambiguous on its face, and that is what the court down and here has done. So what happened underneath? All he has in the record are the rulings, the judgments. None of them address the bill of sale. None of them address Uptown Grill. Uptown Grill.
Are you jumping to the second issue, that it's not?
Well, I'm about to. And the second issue is, and that's what I think Exxon is. The Exxon Supreme Court case, Exxon from 2005. If there's an independent claim, even if Uptown Grill was a party to the state court actions, which is objectively false, but even if it was, if there's an independent claim, even if they were in a party, then you still have the right to bring it because you have a right to address your contracts in appropriate forum.
That's where, again, Rooker-Feldman is not something we encounter that often. It has been narrowed, Exxon. Yes, it does allows independent issues to arise, but not ones that are inextricably intertwined. So wouldn't the argument here be, isn't the argument, well, the license is inextricably intertwined with the bill of sale?
That would be their argument,
Yes.
but that would be incorrect because this court has already determined that those contracts are separate.
But I thought one of our opinions did acknowledge the broad, or the first time interpretation of the bill of sale did, and the phrase something, it was turned the license into a relative nullity. Am I misquoting that? You remember that expression, relatively null?
In the 2019 opinion, there was some discussion about that. That was never pushed, so it was.
I know, but isn't that sort of their central thrust now? That practically speaking, effectively, although two panels of this court previously said we're not trying to touch on the license agreement, that actually inadvertently they rendered it a nullity.
I can't agree with that.
I know you can't. I'm just, but isn't that?
These contracts were two different things, doing two different things. One is a bill of sale. Something was sold. This court determined what that was, the trademark name, like.
Okay. And intellectual property was stuck in there, and they've got their parole evidence as to why.
Parole evidence to which we cannot look at.
Right, okay, but then we've got the license agreement a few weeks later that was more comprehensively about intellectual property.
And that was addressed by this court and the underlying court as well. What, you said there were some poorly drafted agreements, I think is the quote that you used.
Well,
there may or may not have been. I was not involved.
that was their characterization of
their
the bill of
characterization.
sale.
But that's not what the courts have determined. The underlying courts determined that the license agreement was real and it terminated. Somebody violated the term and it's gone. Gone. The bill of sale was never addressed. This court, Judge Jones, said that the bill of sale was never addressed in the underlying court. That's in the first.
And you say that ends that's the end of it.
That ends the equation because Uptown Grill, state court loser, Uptown Grill's not present. Lance versus Dennis, privity is not enough. You've got to be there. You've got to be able to fight for your rights, and in this case, fight for the rights that were granted to us that we purchased in that bill of sale. We weren't. Where's the due process in that? How can rights in a separate contract that was never litigated in underlying courts be stripped from a party that wasn't even there to defend itself? That is a gross violation of somebody's due process rights. Parole evidence aside, that's basic constitutional law. They can't get past that. And then we have a contract that wasn't actually litigated. No one determined at that point, based on the bill of sale.
No, it wasn't considered. What is also not even presented by either party?
Not presented. In one of them, they list the evidence that was included. There were some letters and the license agreement, not the bill of sale. Why? Because it wasn't an issue. And then what do? They come up here and in the trial court and in their first opinion and say, well, Uptown Grill should have argued about their bill of sale down there. And they should have tried to get a ruling from the state court that they owned it. And what happened here? You guys said no. Number one, that's kind of a backwards latches argument, right? It was kind of applied a little backwards. But at the same time, you guys said no. And now what are they doing? Whereas before they said that you should have, now that they're saying that you did. You can't have it both ways. You can't.
I know co-counsels are going to argue the sanctions. Are you going to argue the injunction a little bit?
Yes.
Okay. Do you want to move to that, or do you want to hit a couple
Yes.
other high points?
So the question here is did the trial court abuse her? Is this 5 minutes left? Or
Yeah, you have 5.
I have
It's just-
5?
Yeah, you do have 5.
The scope of the injunction, that's what we're talking about. The judge granted the injunction. It's within her discretion to do. The question here, in terms of a review standard, is did she abuse that discretion?
Where'd you come up with the most or all? Where'd you come up with that language? Because that seems inconsistent with everything that our court had said previously. It's any of the elements, right?
I don't know if the court said that, and I'm happy to look and
Well, we know what the injunction is.
we know what the injunction
And
is.
that's
The trade dress.
I know, but the most expression seems very vague and different.
So I think that's part of the problem with trade dress in general, right? The trade dress is the overall image of something. It's not one part of something, right? If you go to Taco Cabana back in the 90s with the Mexican restaurants in Texas that kind of started this trade dress in the restaurant stuff, it was all of it. All of it has to...
The ambiance.
It's the ambiance, it's the feeling. In one court that they cite, they actually say, look, pictures are a good way to get you to describe what your overall image is, because doing it narratively is very difficult, because you can't really get an image through words. You take it through pictures, right? So the question in my mind, and they want to use this might standard, it might have something to do in the public's mind. Well, if we have one of those elements, if we take the top off a straw at another restaurant somewhere and hand it to a customer to maintain cleanliness, right? So your hand's still on the paper. Is someone might associate that with Camellia Grill? And how are we going to prove that? I mean, isn't that kind of back to the likelihood of confusion standard in regular trademarks anyway? You have to test what the public's might is. Does he get to determine what might is? If so, I suggest you guys will be back here probably pretty soon.
But there is no other restaurant anywhere at the moment.
Our clients own other restaurants. Our clients do not own another grill that looks like this. That is, the last one was shut down, and I think it was 17 or 19, 2017 or 19, I forgot the actual date, December of 19, I believe. But there are no other diners. There's no other Camellia Grills. The Charter Street, which was kind of the impetus of the current trade dress stuff and this particular ruling, that was a Charter Street location, which is closed down. So, again, they cite cases. The judge had the latitude to do several things here. I mean, she could have gone overboard. She could have gone light. That's her discretion. And if we're talking about an abuse of discretion standard, how can we sit here and say that based on everything she's seen in this case for 8 years, that the way she crafted this particular injunction, which just says that we are enjoined from using the trade dress, right? That's what the injunction actually says. How can we say that she abused her discretion in that regard? She had the ability to do a might standard, although I wouldn't suggest anybody spend a lot of time trying to find that standard in the law. That doesn't exist. Likelihood of confusion is the typical standard for this. I understand this is a contract matter, not a Lanham Act matter, but one of the problems we had all along is how do we define this thing? I'm as upset with the 8 factors that the court found as he is. I find it interesting now that he says that was just thrown in there when the language he talks about the underlying courts is all of a sudden gospel. But the contract just says trade dress. How's anybody supposed to know what that is? We made that argument to this court, I believe, that how are we supposed to know what elements they are? Now he's talking about waitstaff attire. How did we know that? I mean, was it the pink walls? Was it something else? I don't know. It's not set forth in the contract. That part is ambiguous. This court decided otherwise. We live with it. The 8 factors are set. But there is no way for those 8 factors to be expanded at this point. The judge offered them, the trial court offered them a chance to try the case and determine what the factors are. And they said they didn't want to do it. They said, no, that's just a waste of time and money. We don't want to come back here and have to prove to you what they are. So she said, okay, we're going to look at the Fifth Circuit ruling, and we're going to apply those 8. And now that's not good enough. Well, wait a second. You had the ability, the right, the opportunity to go prove whatever factors you wanted, and you chose not to. And now they want you guys to expand those factors. They missed their chance on that. So what she did, in my opinion, is objectively reasonable. What she did, in my opinion, is absolutely not an abuse of her discretion, her broad discretion in defining what that injunction was. Could we have argued that the injunction should be broader and it should be all of it? It says trade dress. That, in my mind, means all of it. If it's the image, then it's the image. It's all of it, all of the 8 factors. And if we use 7 of the 8, I could argue, and would, that we haven't breached it, because it says, the contract says you can't use the trade dress, and they have defined what it is now. You guys have defined what it is now. So if we're not breaching them all, then we're not breaching the trade dress. She pulled it down to all or most. That was a bone thrown to them, in my opinion, not a slight to them. They want 1. I would suggest there's no court.
But thank you very much.
Thank you, Your Honor. I appreciate it.
Ms. Borrell?
Good morning, Your Honors. Like Mr. Henskins, I am privileged in a sense that this is my 4th appearance before this court in this case between these parties. And Judge Higginson, I've been impressed with your knowledge of this court's many rulings, but the fact that we have 3 Fifth Circuit opinions already is exactly why there was a motion for sanctions filed in this case. In March of 2020, the opposing parties filed a motion requesting that the district court issue an injunction. Months later, they filed a motion asking the district court to vacate every federal decision since December 3rd of 2013. At that point, it became obvious to us that the litigation tactics that were being employed were duplicative, were vexatious, overly litigious, and we filed our motion for sanctions. I don't think it's lost on Your Honor that the merits are pretty resounding here, but the issue before this court is not necessarily the merits of why their filings are so abusive, but the procedural aspects of Rule 11, which is the grounds on which the district court denied the motions for sanctions. Rule 11 is pretty clear, though the one issue that the court turned on, this idea of an identical filing standard, is not in the rule. The rule, when you read it, has essentially 4 requirements. Federal Rule 11C, subsection 2, motion for sanctions, requires that your motion be made separately from other motions. Our motion for sanctions was separate. The only thing requested in that motion was sanctions and attorney's fees. That it described the specific conduct that allegedly violates Rule 11B. Our alleged conduct is clear both in the motion that was served on opposing party and the motion we filed with the district court. The fact that the opposing parties were requesting to upset 8 years worth of litigation after they themselves utilized the federal courts for 8 years to obtain several rulings against us was abusive. And it was made clear to the opposing party that we thought their Rooker-Feldman motion violated their obligations under Rule 11. That's very clear and distinct in both the motions served on opposing counsel and filed with the district court 21 days later. Third, the motion must be served under Rule 5. That is where we are different than most of the cases cited by the opposing party. While some of the other district court or circuit court cases do reject a Rule 11 motion for sanctions because it was not properly served, ours was properly served. Now, we do not dispute that the motion that was filed on opposing counsel was slightly revised before it was filed with the district court. That is not disputed, and it was clear, as we explained, we did that because the arguments contained in that original motion were repetitive of the opposition to the Rooker-Feldman motion filed the very next day. But the law is the same, and the grounds we state are the same. We list 3 very specific reasons to the opposing party why we believe their motion to dismiss was sanctionable.
How can you justify the additions to the motion? I can understand maybe the deletions because you think they're duplicative, but what about the 100 lines of new text that you added to the motion?
Your Honor, there are 2 substantive additions. The first is we add in law discussing 28 U.S.C. 1927. We would justify that by saying 28 U.S.C. 1927 has no requirement that we file or serve those arguments on opposing counsel prior to filing it with the court. So our 1927 argument shouldn't be precluded by the fact that it wasn't previously served. The only other addition that was a change was a alternate remedy we requested. Originally, we requested sanctions and attorney's fees. When we filed it, we added a one-paragraph request saying, also, please prevent them from filing another lawsuit against us without obtaining leave of court. So that second addition, Your Honor, is not the grounds with which they need to be warned. It was not the grounds with which they needed 21 days to contemplate whether they would move it forward. It was an additional request for a remedy.
But you agree with me, right, that our precedent requires more than giving them notice, because otherwise you could just serve a bunch of demand letters that say, hey, we're going to move for sanctions, you did this, we're going to move for sanctions, we're going to move for sanctions, and then you wouldn't actually have to file serve the motion on them before filing it with the court. So it's obviously more than notice. The whole point of our precedent is to say, you got to show them the motion before you file it at the court.
Yes, Your Honor, it is more than informal service, I believe, was the issue in the In re Pratt case, which we think is very distinguishable. We filed a full motion that showed the severity of our actions and how serious we were. The grounds are the same. We're very clear in how we argue. We say they're vexatious and duplicitous, they mischaracterized prior litigation, and it was abusively untimely. They had all due notice, and for that reason, we believe the court erred in not considering our motion for sanctions. Thank you, Your Honors.
Counsel? You've got 5 minutes.
Thank you, Your Honor. I'd like to respond to a few matters if I could. The question about whether the claim was inexplicably intertwined, I think, is important. And one way to focus on the fact that it is to recall that 30 days after the federal court judgment became final, Mr. Coder filed this bill of sale action, and in that bill of sale, he says that Uptown is the rightful owner of the trademarks, whereas the state court said Mr. Schwartz is, at 626 South Carrollton. Also that Schwartz has claimed complete ownership of the trademarks, obviously under the federal court action because he filed a cease and desist letter to stop using it within that 30 days. So there's no doubt that the bill of sale action that we're here on today was attacking the state court judgment, and obviously they're inextricably entwined because we now have no state court judgment. We have no license that we can enforce at Uptown. Although that's clearly the purpose of the license, clearly stated by Mr. Coder, that's the purpose of the license in state court. It was not disputed in state court, but it was within the court's holdings that Mr. Schwartz owned it and owned it at Carrollton, owned the intellectual properties, and it was terminated. I would also point out that on the Rooker-Feldman is a de novo review by the court. It's not a discretion with the state court, with the lower court, excuse me. And so I'd ask you to look at it fresh, look at the law fresh, and actually it shouldn't be remanded. It should be reversed and granted. Finally, as to sanctions.
Before you get sanctions, do you want to speak to Hall v. Hall and the Rule 60 argument?
Yes, sir. I'd be glad to. Okay. First off, in every time that this matter has been appealed to this court, it has been remanded, and what the lower court granted has been shrunk and expanded. Every action, let me see if I can find the exact quotes. In the July 15th final judgment before this court, it actually was sent back.
Well, we know what happened in the remand, but just specifically his argument about consolidated cases.
Yes, Your Honor. So my point is, his claim was that he owned the trademarks, and then ultimately it grew to be the trade dress everywhere in the world. And every time that issue came up before this court, including as the last time, this court has reversed it and shrunk down what the district court gave it. So the claim of ownership of the trademark is what is still before us today under the bill of sale. Okay. So it's not a separate consolidated issue. So
go ahead on to the sanctions.
Okay. First of all, I would say that under Rule 11C2, the way the rule is worded, it says the motion must be served. It doesn't say a motion. It doesn't say a substantial motion. It says the motion must be served. And then I would cite to Fifth Circuit case of Elliott as well as Adkins, where they say a copy of the motion must be served. It's not the motion or a substantial version of it. It says a copy of it must be served. Now, I will admit that this court has never ultimately ruled on the issue, but every district court I could find in the Fifth Circuit that has ruled on the issue said it has to be the exact copy provided. There's not one district court case that I could find that said it's okay just to send a substantially appropriate one. So that would be my first point. Second point is he changed legal arguments. He changed the Rule 11 law cited by adding the 1927 law. He asserted certain affirmative arguments that were not in there to begin with, and he changed the requested relief. So it was, and the district court found that it was substantially different. And I think the district court in this case, unlike Rooker-Feldman, is supposed to be given the discretion to make that decision. Okay? So I would say that we have one other point to remember is we've won on each appeal. Okay? And we've ultimately won $250,000 worth of attorney's fees from Mr. Coder to us. So we're not protracting the litigation vexously. We are winning in certain situations sufficient that we are the ultimate winner. The Rooker-Feldman is a subject matter jurisdiction question that can be brought up on appeal. Okay, so we don't waive it by not bringing it early. And the motion for sanctions is based on filing the Rooker-Feldman appeal, or the Rooker-Feldman issue. So I think there's no basis to the Rule 11, plus they didn't file us the original agreement. So, Your Honor, I appreciate your time.
Thank you, counsel. The case is submitted, and that concludes the cases for this session. All right.